Hi, everyone. Harry here to talk about two decisions of the Supreme Court on basically procedural emergency docket motions, and they seem technical and bureaucratic. Well, let me cut to the chase. This is the kind of day that progressives have feared since the Trump victory in November. By lockstep majorities, 6-3, the six Republican, Thomas, Alito, Roberts, Kavanaugh, Gorsuch, and Barrett, with Jackson, Sotomayor, and Kagan on the other side, the court permits the executive branch to do some funky stuff and does it via this emergency docket, which is really they use increasingly a very problematic way to go for important merits cases. And it is emerging as a near foregone conclusion that when we have these big emergency docket cases where the administration comes in and says, you must get rid of this stay emergency, they have reliably in the last year, something like 18 of 19 times granted this relief. All right. Both cases involve DOGE, and the first one involves access to Social Security data for DOGE. And the administration says, you DOGE folks, go in and you can have access the way the Social Security Administration, and only the Social Security Administration, generally has access to taxpayer data. That is you and me and our Social Security numbers, and all that is now in the claws of the DOGE folks. The first point is this ongoing, I think, kind of bogus debate or notion, and the administration says, oh, DOGE, it's not really an agency, it's just kind of a group that informally has the ear of the president, and the head of it is this woman, Gleason, and even though she looks to be an employee of a whole another agency, and it sure seemed like it was Elon Musk who was calling the shots, but that's all part of that kind of fiction that now is by the boards, presumably with DOGE out of the way. But the idea in the legal issue is there's no legal prohibition on people within the government having access. There's a strong practice of it being only within the Social Security Administration. For that reason, people are trained carefully and, so as not to disclose. If they do disclose, it's a violation of the Privacy Act, potentially criminal. But the government can say, okay, we're adding these folks, training them, and they can now have access to the information. Judge Hollander, who was the district court judge who looked at this below, said, wait a minute, at least for people who don't have training, you can't just have access to the agency's records. I want to think about whether it's legal, so I put the hold on it for now while we figure it out. And the Court of Appeals did not disagree, so the stay was kept in place. So the first thing the Supreme Court did on Friday was it removed the stay by a flat out 6-3 decision. And as these emergency docket cases tend to go, with very little detail, just really elliptical. It's an unsigned 3-paragraph order. And what the thing that it basically turned on is likelihood of success. And for the reasons I said, presumably, I mean, it's just not much detail at all, but presumably that's what the 6 on the Supreme Court have in mind in letting it go. Now, the focus of the 6, but it's unsigned, there's very little detail, but it seems to be this idea that they will eventually succeed. But Justice Jackson dissents here, a 10-page dissent. Sotomayor joins her. Kagan, interestingly, doesn't join, but she also dissents. But Justice Jackson, is making a point that she's now become kind of the mouthpiece for, which is, you guys are just out of control on this emergency docket stuff and doing too much here. And in brief, to get a stay, here's the status quo. You can't just get it willy-nilly. You've got to show four things. It starts with likelihood of success, but we have other important factors that the government can't show here, namely irreparable harm and balance of equities. Who's going to really get hurt if these records are made available generally to DOGE folks? And just as an aside, though this wasn't part of the case, who is DOGE now? A remaining shell of presumably Musk loyalists who are at war potentially with Trump and the administration and will use whatever dirty tactics they have. I mean, I don't trust DOGE to think responsibly and governmentally. DOGE, I don't trust Musk's remaining sort of lieutenants there to do so. Anyway, Jackson says, look, there are four things here and that you need them to grant a stay. You're just basically ignoring irreparable harm, ignoring balance of equities. The fact is that the government's not going to be greatly prejudiced if we just keep the hold on until we decide what is legal or not and whether DOGE can have this information. But so a flat out 6-3, not much reasoning, a sort of pro-executive power, pro-Trump ruling, this sort of thing that, we have worried and continue to worry is going to be endemic with this Supreme Court and this president and these 4 years. And the second case to tell you about is sort of a piece. So it's a lawsuit by a citizens group saying, who the hell is DOGE? Please, we need some information. And here's a FOIA request so we can get information. Now, FOIA by law is something you use to get information about and from agencies. So it's this threshold question because the administration is hewing to this canard. No, they're not. They're just a sort of amorphous bunch of advisors. They're not an agency. But that's the question in the case. So the district court, in this case, Judge Cooper in the D.C. District Court, Hollander is from the Fourth Circuit of the district in Maryland, and Cooper's across the river, but it's the D.C. Circuit. So he's in D.C. said, yeah, I'm going to grant some very limited discovery here. One, I'm going to permit you to depose the woman, Amy Gleason, who the administration is advancing as the actual head of DOGE. And I'll let you get some other information about whom they've sort of dealt with and what their findings have been, things from which we can figure out, are they an agency? And from there, we can figure out, are they subject to disclosure under FOIA? So that's his order. And the Supreme Court, 6-3, arguably even less information, says, no, it's too intrusive. You don't need all of this stuff in your discovery order in order to get at what you're trying to get at. Moreover, this, is sends a little bit of a chill down your spine, but they say there's separation of powers concerns, being too intrusive on executive branch workings and the like. So they send it back to Judge Cooper in theory to sort of tailor it more. It's not, there's still the possibility of getting some information about this agency or not agency, but either way, it's a group that is really affecting American lives, right? Including, say, Social Security data, as I just talked about in the other case. But the court said you reached too far, Judge Cooper, and you need to tailor it more. And we are not going to do it super quickly as you have, as the plaintiffs have asked us to. So we're putting this on hold for now and sending it back to the DC Circuit, the court just below us, typically not the district court, so they can review and in the first instance decides what information should be subject to discovery, which they just decided not to grant relief, as happened in the other case. No, think about it more. Kagan Sotomayor, Jackson all dissent, but without any explanation. They said, we'd have denied the government's request. So two cases, it seems like kind of procedural. Do you keep the stay in place or do you not? But two real victories for the government and two real blows by the Supreme Court on behalf of the principle that DOGE, which in some ways is the entity par excellence for undertaking this kind of secret, unreviewable series of measures that hugely influence American life. You know, the two more ways in which Trump's overall effort to do this all in secret and displace it onto this whole new entity are upheld for now. Again, it's preliminary. And it has to do with whether or not to grant a stay, and things will still go on, et cetera, et cetera. But the writing is very strongly on the wall, that of approving this kind of power by, DOGE. And it's just unmistakable. I try not to be too, political lockstep. Oh, it's the 6 versus the 3, but it's the 6 versus the 3. And in another YouTube from this morning, it's the 2 versus the 1 in the DC circuit. The day overall is one in which by luck of the draw in the DC circuit, who is the panel, and by very much not luck of the draw in the Supreme Court, where a generation of Republicans have been able to engineer an uber conservative majority, by an absolute divided court in both instances, the pro-executive branch and more pro-Trump, I don't want to say in lockstep, but they're the ones who he looks to flex their muscles for him, and really that's the end of the line on these immediate disputes, but the general preview of what could happen in cases that involve core assertions of expanded executive power by Trump are ominous. Now, it's different from their keeping their hands off and not reviewing at all, which is the thing we've been most afraid about. But the second thing would be reviewing and just in lockstep, and especially here without even much reasoning. They say, yes, Donald Trump, you can let DOGE have Social Security data. Yes, Donald Trump, we agree with you. You can't be too intrusive in the questions you even ask DOGE. Yes, Donald Trump, it's expanded executive power, but that's okay with us. A worrisome day, to say the least. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.